hundreds of thousands of people's lives depend on the definition of priority needs, and that might seem like a little melodramatic, but if you think about it, I'm not necessarily talking about life or death situations, although that does happen as well for sure. People obviously who are homeless, particularly street homeless, are at much higher risk of death. But it just has a profound impact on people's lives, as in hundreds of thousands of people will arrive at a point where there is a fork in the road, and the question is, will the council help them or will the council leave them homeless? And often the answer to that question will remain with them for many years. And you would therefore think that the definition of priority needs would have been clearly set out within the law, and in some cases it is. So for example, if you've got pregnant women in the household, if you've got dependent children in the household, if you become homeless because of fire or something like that, then yes, it's straightforward. But we have this standalone category called vulnerability, and we'll talk about it in a lot of detail in this video. But unfortunately, the definition of vulnerability is not set out clearly. It's basically a mishmash of different principles from different cases over the last 10 years or so. And arguably the most helpful case is Paniotu v Waltham Forest, which was a conjoined case. Smith v Haringey was the other case as part of it, where for various reasons it's very good, but unfortunately it is unnecessarily convoluted. And you do have to wonder why they didn't just make this much more straightforward for people to argue. Housing officers who use it the most are not legally trained, and you are expecting them to basically decipher this incredibly complicated definition in their everyday whilst they are under pressure to gatekeep from the managers of many councils. But I'm going to try and tackle it in this video, because if you get it right, there is a bulletproof argument that your client is going to be in priority need. And you might have heard me talk about this case before. I generally refer to it as Smith v Haringey because that's more memorable than Paniotu v Waltham Forest, but it's the same case. It went to the Court of Appeal, which basically means it holds a lot of authority within the law. Sadly, the Thomas v Lambeth case, which you might have also heard me talk about on this channel, which is far more clear and easy to use, that is only a county court judgment. So this Paniotu case, this Smith case, is going to be much more helpful when it comes to essentially winning an argument with the council. And I've taken this formulation from Jan Luber's textbook, Housing Allocations and Homelessness. Jan Luber's now retired, but I think it's not controversial to say that when he was practicing, he was the most respected lawyer in the country when it comes to understanding of homelessness law. And his formulation goes into more detail than the one I've used. I've essentially looked at the case transcript and I came out with a three-part formulation. Jan Luber's formulation arguably includes 5 different steps, which is what I'm going to come to in the video. And in effect, even if you don't quite understand how they all fit together, if you just follow the process and answer each of the 5 questions, you're going to have a very good starting point to show that your client is in priority needs. And I talk about starting point, I would be using this formulation in the initial email I'm sending to the council to trigger the homeless application in the first place. That might be before I've got any evidence at all, but I'm going to be putting what I know about that client in these terms to show the council as best I can that they are going to be in priority need. So before we get to the Paniotu and Smith case, it might be helpful just to recap very briefly about the Hotak case. Now the Hotak case was 2015. It was another conjoined case involving 3 cases. So there was the Hotak brothers, there was Mr. Kanu and there's Mr. Johnson. And each strand of the judgment has an interesting principle, or a very important principle, for our understanding of vulnerability. And just to quote a few bits, it's a very long judgment, but to quote a few bits talking about this definition, basically says that you are in priority need if you are more at risk of harm without accommodation than an ordinary person would be. You then see this kind of principle within the Homelessness Code of Guidance. So in 8.16 it states that you'll be in priority need if you are significantly more vulnerable than an ordinary person would be if they became homeless. Now immediately this begs 2 questions. What does ordinary mean and what does significant mean? And these 2 questions form the basis of a number of cases that came after them. The Paniotu and Smith case is one of the kind of answers what that word significantly means. I'll come back to that in a moment actually. But the Hotak case in itself is a good definition. It's far better than the previous definition. But I'd argue that if you really want to belt and brace an argument that your client is in priority need, you probably want to be using this formulation that Jan Luber suggests. And the other thing it might be worth saying at this point is that the law gives a list of characteristics which are going to be relevant to vulnerability. They're not automatic characteristics, but if you're vulnerable because of these characteristics, then you're going to be in priority need. And there's this catch-all at the end called any other special reason, where we see from case law things like risk of exploitation, things like substance use and risk of relapse into substance use could well be relevant to this question of whether someone's vulnerable. Also things like trauma can crop up quite a lot. So if you look at 8.14 of the Code of Guidance, it basically states that you are in priority need if you're vulnerable as a result of any of the following. And if I just quickly go through them, so A, old age; B, mental illness or learning disability or physical disability; C, having been looked after, accommodated or fostered and aged 21 or over; D, having been a member of His Majesty's regular naval, military or air forces; E, having been in custody; F, ceasing to occupy accommodation effectively because of threats or actual violence; or G, any other special reason. So these are the kinds of things that the law is envisaging would render someone vulnerable or could render someone vulnerable. And so if we therefore get into the kind of crux of the Panio 2 and the Smith case, this part refers to Mr. Smith, Stephen Smith I think his name was. He was actually a client of Will Flax, so this was Will Flax's case that got this far. And I'm going to read this out, but you'll see immediately how ridiculously convoluted this sentence is. Why they didn't make this more easy to understand, I just don't know. But if I read it out and then I'll come back and kind of pick it apart. So the question to be asked is whether, when compared to an ordinary person if made homeless, the applicant, in consequence of a characteristic within section 189(1)(c), which is the list we just kind of looked at from the Code of Guidance, would suffer or be at risk of suffering harm or detriment which the ordinary person would not suffer or be at risk of suffering, such that the harm or detriment will make a noticeable difference to his ability to deal with the consequences of homelessness. So as I say, why they didn't make that more straightforward, I just don't know. But if we just boil it down a little bit, so I've taken a bit of a liberty here, but I've basically simplified this sentence out in order to try and understand what it's really getting at. So the question to be asked is whether, when compared to an ordinary person if made homeless, the applicant, in consequence of a characteristic listed in the Code of Guidance, would suffer or be at risk of suffering in such a way that the harm would make a noticeable difference to his ability to deal with the consequences of homelessness. Still not very helpful yet. You know, still a bit of a mess, but I think what the judge is saying here is that healthy and robust people will be harmed by being homeless, but not in a way which is going to impact on their ability to find accommodation or deal with the lack of it. Now, I'm not going to die on that hill, but I think that's what he's saying. Whether I'm right or wrong about that, the following is definitely going to be legit. And actually, if you read a little bit further on within the same case, the judge went on to say that to put it another way, what Lord Neuberger must have meant was that the applicant would be vulnerable if he were at risk of more harm in a significant way. Now, that terminology there, that formulation, more harm in a significant way, probably gets you 90% of the way there. So even if you kind of don't understand the ins and outs of the rest of this, if you just frame your evidence that someone's in priority needs by showing how they are at risk of more harm than an ordinary, healthy, robust person would be in a significant way, then you're going to be thereabouts and actually showing your clients in priority needs. The following is going to kind of add that remaining 10% to it. And just to explain what significant means here, the word significant is obviously quite a flexible word within the English language, and you see it actually used slightly differently in different cases, but the judge actually goes to some effort in this case to explain that the word here, in this case, in this context, is where the issue is relevant and also noticeable, and both of those are important. So in terms of relevance, Jan Luber makes the point that some issues, let's say fear of heights, might have a debilitating impact on someone who's homeless, but because being homeless doesn't bring with it any risk of being at height, really, it's not going to be relevant to whether that person's in priority need. So the issue needs to be relevant to homelessness. So a good example of this might be arthritis, because sleeping on a cold concrete floor is clearly going to be relevant to the health condition and being homeless. And the other arm here is this word noticeable, and this is why this case is absolutely worth the effort, because before this we saw counsels try and advance the argument that this word significant should mean something that's kind of really quite extreme. And in this case, the judge actually quotes Minos Perdios from Housing Reviews Limited, who basically carries out reviews for councils, lots of different councils around the country. And in this case, Minos Perdios had actually written the review for Mr. Smith. And in that review decision, he said that it may very well be the case that you, as in Mr. Smith, are more vulnerable than ordinarily vulnerable, but I'm not satisfied that you are significantly more vulnerable than ordinarily vulnerable. And then the judge basically goes on to comment that if Miss Perdios concluded, as he said he had, that Mr. Smith might well be more vulnerable than ordinarily vulnerable, he seems to me to have performed the comparative exercise required by Hotak. At that point, he ought to have concluded that Mr. Smith had a priority need. So in effect, as soon as Minos Perdios had noticed that there was something about Mr. Smith which put him at this risk of more harm in a significant way, that was enough. He can't then move the goalposts and kind of give an artificially high meaning of this word. And so if we get to Jan Luber's formulation of this test, he essentially separates that into 4, arguably 5 parts. I'm actually going to separate it out into 5 parts just to make it kind of as basic as I can. So he basically states in his textbook that an applicant who will, if without accommodation, suffer or be at risk of suffering from harm that will impact on his ability to find accommodation or deal with the lack of it, will be noticeable in extent and would not be experienced by the ordinary person, that person might properly be regarded as being in priority need. I'm paraphrasing that last bit. And what I've done here is I've taken a bit of liberty with this and I've separated it out into 5 different arms. So it's actually 1, 2, A and B, and then 3 and 4. And I put these numbers in here so I can then kind of refer back to them in order just so you can see what I'm talking about. So 1, an applicant who will, if without accommodation, suffer or be at risk of suffering from harm that. 2A, will impact on his ability to find accommodation, or B, deal with the lack of it. 3 will be noticeable extent, and 4 would not be experienced by the ordinary person. Then they'll be in priority need effectively. And I'll just draw your attention to this use of the word or here. Now that's an interesting word. I don't know if it was intended or if it was supposed to be significant, but the way I would read this sentence is that someone could be in priority need if they're going to suffer harm or they're at risk of suffering harm that is either going to affect their ability to find accommodation and or deal with the lack of it. That's how I would read the sentence. Now again, I'm not going to die on this hill for that one. It's just interesting that the case itself uses that formulation, because what Jan Luber's done here is he's not just made this off the cuff, he's gone through the judgment and he's basically drawn out these different strands and put it into this particular formulation here. So he's not making this stuff up, it's taken directly from the Paniotto and the Smith case. So if we deal with this first point first, so the applicant who will, if without accommodation, suffer or be at risk of suffering from harm, that ... So here is probably the most labour intensive part of this test. This is where we need to establish what we think or what may well happen to this person that we're supporting if they were to be homeless. So effectively we want to be labouring the point of what harm they would or are likely to suffer if they were to become homeless. Now sometimes that's a hypothetical test because they've never been homeless before, but it's probably safe to say that if someone has significant depression now, being homeless is probably going to make that depression get significantly worse. That's probably not too controversial to say. And so in most cases you're going to be talking here about physical or mental health issues in general, because if you go back to that list, you know, veterans, people who've been in prison, people who've come out of care, that sort of thing, in most cases you're still going to use probably a mental health diagnosis to illustrate the impact that's had on them. So, you know, to kind of use the stereotype, a veteran, you know, would be in priority need if being in the forces led them to develop PTSD. That would be the kind of argument we're talking about here. Now again, just to be really pedantic, the label of PTSD in itself is not going to confer priority need. You again have to unpack this word vulnerable. But other things that we see in case law, things like substance use, things like lack of experience managing a tenancy, lack of support network, history of sleeping rough, risk of exploitation, all of those kind of things could kick in here. So I'm not saying it's only mental health and physical health issues, but in a lot of cases it will be. And so it's really for you to work out, you know, to think outside the box of what kind of harm you think your client would suffer if they were homeless. And as I say, just treat that as a kind of everyday use of language. So don't kind of just think in these kind of boxes of what the law says it might be. You know, it might be that actually being homeless is going to have a serious effect on their support network. That again, I think could qualify as a harmful effect. So once we've established what we think is going to happen to our client, we then need to get to this rather annoying bit here, which is to work out whether the harm that is likely to happen if they were homeless is then going to impact their ability to A, find accommodation, or B, deal with the lack of it. So the fact that they've come to a home service, assuming, you know, if you're a professional working in the homeless sector, if that person's come to your service, then it would seem fairly, you know, safe to say that they have struggled to find accommodation themselves. So they are there because they have not been able to find their own accommodation. So, you know, you're already kind of in the ballpark of what we're talking about here, but what we need to do here is to show why the harm they're suffering has impacted their ability to find accommodation. So let's take the example of someone with depression. Now, depression is, you know, quite a broad diagnosis, but it could be characterized with things like lack of motivation, hopelessness, being overwhelmed, kind of just, kind of giving up, more easily, something like that. And then if you think what's involved in finding accommodation, ringing around lots of landlords, applying to different estate agents, getting knocked back again and again and again because you're competing against 50 different people for the same property, you could see how someone with depression is going to probably give up before someone without depression. I think that's pretty safe to say. So that's the kind of thing we're talking about. And if you use the example of a physical health issue, let's say arthritis, the harm that they're going to suffer if they're homeless is the pain's going to get worse, the mobility's going to get worse, and therefore they're going to struggle to go and look at estate agent windows, go and look at properties, get out and about to go and do those things to find accommodation. So that's kind of what we're talking about here. So it's not just that they're going to suffer harm if they were homeless, you have to then tie it to one of these two things, arguably both things. I don't really know how, as I say, this what used the word "or" is just interesting. So is there an impact on the ability to find accommodation, and if they can't find it, to deal with the lack of it? And again, what does it mean to deal with a lack of accommodation? There is a bit in another part of this case where it says that the impairment may be an expectation that a person's physical or mental health will deteriorate, or it may be exposure to some external risks such as risk of exploitation by others. So that's kind of think what they're talking about here. But I guess in more practical terms, what does it mean to deal with being homeless? You potentially be talking about things like, can you look after yourself? Can you make sure you're getting adequate nutrition? Can you make sure you've got the wherewithal to find spots to sleep which are not going to put you at risk of being beaten up, something like that? So the kind of the practicalities of being homeless. And let's say someone who's got depression and becomes homeless, their depression gets worse. It may well be there's a tendency there to self-neglect, so they stop eating healthily, for example. That would be, I think, what we're really talking about here, about dealing with the consequence of being homeless. But again, it's not exactly clear. I think if you're talking about someone whose health is going to deteriorate significantly, noticeably, then I think that may well be enough here. What this case does say, that it's not a question of whether that person can fend for themselves, because you see, some people who've been rough sleeping for many years can fend for themselves. They know the system, they kind of know the spots. In a sense, they've got very good at surviving. That does not mean to say that they're not vulnerable. So, as I say, the case does make that point. I've certainly worked with people rough sleeping who've even been able to maintain jobs because they've got their own little spot. It might be a tent kind of out of the way, or it might be under a bridge or something, and that has enabled them to be relatively stable. But that in itself does not mean they can't be vulnerable. So that's the complicated bit. The last two strands, so the idea of it being noticeable in extent, well, if you've got this far, then by definition it is noticeable, right? Because if you've got something which is a harmful effect, which is then going to have an impact on that person's ability to find accommodation or deal with the lack of it, you've noticed it already, right? So you've kind of ticked this box already. And that's why in my formulation, in my version of this test, I kind of mixed them in with the first part. And then finally, would this harm be experienced by the ordinary person? And there's another case called Geist, which actually happened after this. But in that case, in the Geist case, it was shown that the ordinary person is specifically someone without any of those characteristics listed in section 189. So you're comparing your client who has depression with a hypothetical person who doesn't have depression. And you're essentially trying to show that there's a difference in the effect that that would have if they were homeless. So I don't know how clear any of that was. I'm going to excuse myself here and say that the case genuinely isn't very helpful. It isn't very well set out. And maybe I'm doing Jan Luber a disservice here, but I also think that he probably also struggled to kind of come up with this formulation, because it's part and parcel of a much wider discussion within the chapter in the textbook. But I think even if you don't fully understand how it all fits together and kind of these little nuances, I think if you focus on particularly the first three parts of it, so what harm are they going to suffer if they're homeless or be at risk of suffering, how is that going to impact their ability to find accommodation, how is that going to impact their ability to deal with the lack of accommodation, then I would argue you're probably already going to have passed the kind of principles, because as I say, you've already noticed it, and you've probably already shown that it's not something which the ordinary person would suffer from, because you've highlighted the fact your client has depression, has arthritis, whatever it might be. So I'm hoping this is going to be useful for people to take forward, particularly for professionals, because as I say, you see, it's just nightmarishly complicated. But I think once you start using it, and again, kind of coming back to this kind of information, come back to this video. If you want to buy the textbook, then it's expensive, but it's absolutely worth the money. And basically just kind of really just dwell in this chapter, dwell in this section about priority needs, because if you understand it, because so much rides on whether or not you're in priority needs, you're going to find that if you get your head around it, you're almost certainly going to understand it more than the housing officer who's on the other end. And if you understand it really well, you're going to find that you can anticipate the kind of things that housing officers tend to say to try and refute you. And so you're more likely to get it right from the start and hopefully help the council make the right decision the first time rather than having to go through the review process. So yeah, if you've got any questions about it, as always, stick it in the comments, anonymised. I will take it through to the next live stream, which is generally on a Thursday, 7:30 p.m, to discuss it further there. And if you want to get your head around this stuff in more detail, do check out our online training, because although we don't go into the level of detail I have in this video about priority needs, what we do in that training is we spend the day just basically setting out the foundations of housing law, of homelessness law, looking at things like what's a homeless application, what's gatekeeping, and then crunching through the 5-part test. So what's the definition of homelessness, what's the definition of priority, what's the definition of intentional homelessness, and so on. And that then means you can then build up your understanding from that foundation, which I think is probably a good way of doing it. So yeah, as I say, hopefully that's useful. It's hurt my head, hopefully it's not hurt your head too much, and I'm hoping that you can put it into practice and kind of practice kind of doing this to kind of become more and more effective at getting people housed.